Imagine a Treasury Secretary going on national television and threatening to cut off trade with America's closest allies, the United Kingdom, the European Union, Canada, because a court told the president he couldn't unilaterally tax the entire world. That is exactly what happened on Friday. And the fact that Scott Bessent delivered that threat with a straight face, on a network that functions as the administration's communications arm, tells you everything you need to know about where this White House is right now. The U.S. Supreme Court struck down the legal foundation of Donald Trump's sweeping global tariff regime, and instead of accepting the ruling, regrouping, and working through the constitutional process, the administration responded with a combination of self-pity, legal threats, and what can only be described as economic hostage-taking. This video is going to break down exactly what the court ruled, why it matters, what the administration's response reveals about its understanding of American governance, and what the economic data, which was already damning before Friday's ruling, tells us about the real-world consequences of a trade policy built on a legal fiction. Buckle up, because this one goes deep. To understand why Friday's Supreme Court ruling landed like a bomb inside the West Wing, you need to understand what the Trump administration had been doing for the better part of 2 years. Beginning in early 2025, the administration invoked the International Emergency Economic Powers Act, commonly known as IEEPA, to impose sweeping tariffs on virtually every trading partner the United States has. The legal theory was straightforward. If constitutionally aggressive, the president, acting under emergency authority, could unilaterally impose tariffs without congressional approval. At its peak, the tariff regime covered trillions of dollars in imported goods, with rates ranging from baseline levies to punishing sector-specific duties. The administration claimed these tariffs were generating massive revenue. Trump himself repeatedly cited figures in the trillions, and that they were forcing trading partners to the negotiating table, producing what the White House described as historic trade deals. On Friday, the Supreme Court disagreed with the legal foundation of all of it. The ruling was not, as the administration immediately tried to spin it, a close call or a partisan attack. The court's core holding was constitutionally straightforward. Tariffs are a tax. The Constitution explicitly grants the power to levy taxes to Congress, and Congress never delegated that power to the president under EPA in a way that authorized what the Trump administration did. The court did not say tariffs are unconstitutional. It said this president cannot impose them unilaterally. If Trump wants tariffs, he needs to go to Congress. That same day, Trump held a press conference that, by any objective measure, was unusual. He complained about the ruling, suggested the justices were confused, and announced he would impose a 10% across-the-board tariff using a different statutory authority, Section 122 of the Trade Act of 1974. He also indicated tariffs would go higher, not lower. Then, Bessent went on Fox and threatened embargoes. The administration's position, stated plainly, was, the court can say what it wants, we will find another lever. To appreciate the full weight of what the Supreme Court did on Friday, you have to go back to the foundational architecture of American constitutional law on trade. Article 1, Section 8 of the Constitution is unambiguous. Congress has the power to lay and collect taxes, duties, imposts, and excises. This was not an accident. The founders, having just fought a revolution partly over taxation without representation, were deeply intentional about placing the taxing power in the people's house. For most of American history, that structure held. Congress set tariff schedules, sometimes delegating narrow authority to the executive to adjust rates within defined parameters. The Smoot-Hawley Tariff Act of 1930, the last time Congress exercised this power in a sweeping, unilateral way, is the canonical cautionary tale. Smoot-Hawley raised tariffs on over 20,000 imported goods, triggered retaliatory tariffs from trading partners, and is widely credited by economic historians with deepening and prolonging the Great Depression. The lesson policymakers drew from Smoot-Hawley was not that tariffs are always wrong, but that sweeping, poorly designed tariff regimes imposed without adequate deliberation cause cascading economic damage. The post-World War II international trade architecture, GATT, then the WTO, then a web of bilateral and multilateral agreements, was built explicitly to prevent a repeat. What makes the current moment historically distinctive is not that a president wanted tariffs. Presidents have always wanted tools to manage trade. What was unprecedented was the legal theory that a president could impose a global tariff regime of this scale and duration using emergency powers designed for targeted, time-limited interventions. The court's ruling on Friday essentially said that theory was always wrong. The emergency power was never meant to be a permanent tariff authority, and using it that way violated the constitutional separation of powers. Now let's get into the 5 dimensions of analysis that actually explain what Friday means, legally, politically, economically, in terms of public opinion, and internationally, because each layer reveals something the others don't. On the legal and procedural front, the ruling's immediate practical effect is more complicated than either side is admitting. The court remanded the case back to lower courts, which means the question of what happens to the approximately $130 to $175 billion in tariff revenue already collected is not yet resolved. Justice Amy Coney Barrett, who was present at oral arguments, reportedly flagged this exact issue, noting that the refund question could take months or years to litigate. Bessent, when pressed on whether the government would refund the collected revenue, declined to commit, saying he would not get ahead of the courts. Read that carefully. The administration is signaling it intends to litigate the refund question aggressively rather than return money to the importers and ultimately consumers who paid it. On the Section 122 gambit, the legal picture is equally unfavorable for the White House. Section 122 of the Trade Act of 1974 does authorize the president to impose a tariff of up to 15%, but it comes with a hard statutory ceiling, 150 days. After 150 days, the authority expires. There is no renewal mechanism. So the administration's claim that it has reinstated its tariff regime is, at best, a temporary measure with a built-in expiration date. Any serious legal challenge to the Section 122 tariffs would also have to grapple with whether using that authority in direct response to a Supreme Court ruling striking down a functionally identical policy constitutes an attempt to circumvent the court's holding, a question that could itself generate significant litigation. The political dynamics here are, in some ways, more revealing than the legal ones. The administration's immediate response, threatening embargoes, invoking war powers, promising higher tariffs, was not a legal strategy. It was a political performance designed to signal to the base that the president was not backing down. But the performance has a structural problem. The Supreme Court's ruling explicitly pointed to Congress as the solution. If Trump has a compelling case for tariffs, he can make it to a Republican-controlled Congress. The fact that he is not doing that, the fact that the administration is instead reaching for emergency powers Section 122 and embargo threats tells you something important about the internal Republican politics of trade. A significant portion of the Republican Congressional Caucus, particularly members with export-dependent constituencies in agriculture and manufacturing, has never been enthusiastic about the tariff regime. Senate Republicans from farm states have been quietly alarmed for months. The administration knows that a congressional vote on sweeping tariffs is not a guaranteed win, even with unified Republican control of both chambers. That political reality is why the White House has consistently preferred unilateral executive action to the legislative process. The court just closed that door, at least for now, and the administration's frantic search for alternative authorities is a direct reflection of its inability to build a durable congressional coalition for its trade agenda. The economic data that was already public before Friday's ruling deserves its own careful examination because it fundamentally undermines the administration's core claims. University of Michigan economist Justin Wolfers made a point on Friday that cuts to the heart of the matter. When the Supreme Court announced it was striking down the tariff regime, U.S. stock markets rose. That market reaction is not a political statement. Markets are aggregating the judgments of millions of investors about the future profitability of American businesses. The fact that those investors collectively decided American stocks were worth more the moment the tariff regime was struck down is a direct market verdict on the theory of the case. The administration argued tariffs would make American manufacturing more competitive and drive investment into the United States. Markets said the opposite. The tariffs were a drag on American business value, not a boost. Beyond the market reaction, the trade deficit data for 2025 is devastating for the administration's stated goals. The trade deficit for 2025 came in nearly identical to 2024, a difference of approximately 0.02%. The entire theoretical justification for the tariff regime, as articulated by Trump himself, was reducing the trade deficit. Every mainstream economics textbook explains why tariffs are an ineffective tool for that purpose, and the 2025 data confirms it. Meanwhile, the revenue figures the administration cited, Trump repeatedly invoked trillions of dollars in tariff revenue, were wildly inflated. Bessent, when pressed on the refund question, quietly revised the figure down to approximately $130 billion. The gap between trillions and $130 billion is not a rounding error. It is a difference of roughly an order of magnitude, and it matters because the administration used those inflated figures to justify the policy's economic benefits. On public opinion and media dynamics, the administration faces a structural credibility problem that Friday's ruling is likely to accelerate. Polling conducted throughout 2025 consistently showed the tariffs were among the most unpopular elements of Trump's economic agenda, with particular weakness among independent voters and in suburban districts. The administration's response to the ruling, threatening allies, invoking embargo powers, promising higher tariffs, is unlikely to improve those numbers. The media landscape on Friday split predictably. Fox and allied outlets framed the ruling as a judicial overreach and amplified Bessent's embargo threats as evidence of executive strength. Independent and mainstream outlets focused on the constitutional holding and the economic implications. What is notable is the degree to which the administration's own statements on Fox, Bessent calling the ruling a loss for the American people, threatening embargoes against the UK and EU, provided the opposition with ready-made clips that are difficult to defend on the merits. Internationally, the damage may be the most durable. The administration's threat to impose embargoes on countries that do not honor trade deals that, as multiple analysts noted, exist primarily as social media posts rather than binding legal instruments, was received with a mixture of alarm and, in some capitals, barely concealed contempt. Canadian Prime Minister Mark Carney, a former central banker who ran both the Bank of Canada and the Bank of England, is not going to be intimidated by a 150-day tariff. He can count. More broadly, the episode accelerated a realignment that was already underway. The countries that were part of the Trans-Pacific Partnership Framework, which the first Trump administration abandoned in 2017, have been moving toward closer integration with the European Union. What was once an American-designed architecture to keep China at the margins of Pacific trade is now being reconstructed without the United States, notably without China as well. The two countries being treated as unreliable partners by the rest of the world's major trading blocs are China and the United States. That is a generational reputational cost that no court ruling can undo. The stakeholder map on Friday was unusually clear. The administration's core constituency, the voters who supported Trump on the promise that tariffs would bring manufacturing jobs back and reduce prices, is the group most directly harmed by the policy the administration is defending. The tariffs were, by any honest economic analysis, a regressive tax. They fell disproportionately on lower-income households that spend a higher share of their income on imported goods. The administration's trade representatives suggested publicly that this analysis was incorrect. The administration's own economic advisor subsequently confirmed it was correct, and then suggested disciplining the Federal Reserve economist who documented it. That sequence, deny the finding, confirm the finding, threaten the people who produced the finding, is not a policy response. It is an attempt to manage information. The corporate sector, meanwhile, has been quietly lobbying for relief from the tariffs for months, with particular intensity from retailers, automakers, and consumer electronics companies whose supply chains are deeply integrated with Asian manufacturing. The Supreme Court ruling was, for that constituency, a significant win. The financial sector's reaction, stocks up, reflects that alignment. The agricultural sector, which has been hit by retaliatory tariffs from China and other trading partners, is another constituency with a direct interest in a more stable, rules-based trade environment. Farm state Republican senators are watching Friday's ruling carefully. Looking ahead, the most likely near-term scenario is a period of legal and political turbulence as the administration tests the limits of its remaining authorities. The Section 122 tariffs will face immediate legal challenges, and the 150-day clock means any manufacturing investment decisions premised on their permanence are economically irrational, a point Wolfers made with precision. The embargo threat against trading partners is legally available to the president under certain statutory frameworks, but deploying it against the UK or EU would trigger retaliatory measures that would dwarf the economic impact of the original tariff regime. A more optimistic scenario involves the administration quietly negotiating with congressional Republicans to pass a narrower, more legally durable tariff authority, one that could survive judicial scrutiny because it would represent a genuine congressional delegation of power rather than an executive power grab. That path exists, but it requires the administration to accept a political dynamic it has consistently resisted, sharing power with Congress. The worst-case scenario involves the administration escalating through embargo powers in Section 232 and 301 authorities in ways that trigger a full-scale trade war with European allies, at a moment when the U.S. economy is already showing signs of stress. GDP growth running below projections, consumer inflation measures coming in hotter than expected, and the trade deficit unchanged despite 2 years of tariff policy. The wild card is the refund litigation. The lower courts move quickly and order the return of $130 billion in collected tariffs, the fiscal and political implications would be significant. What Friday ultimately revealed is a tension at the core of this administration's governing philosophy that no executive order can resolve. The president wants the power to reshape the global trading system unilaterally, on his own timeline, without the friction of democratic deliberation. The Constitution says that power belongs to Congress. The Supreme Court, in a ruling that was not close and was not partisan, said the same thing. The administration's response, reach for the next lever, threaten the next country, discipline the next economist, is not a governing strategy. It is a performance of power in the absence of the legal authority to exercise it. The economic data tells the same story the markets told on Friday. The tariff regime was not making America wealthier. It was making America poorer, more isolated, and less trusted. The rest of the world has noticed. They are building the trade architecture of the next generation without us. That is not a problem a 150-day tariff fixes. If you want to understand where American trade policy goes from here, the most important variable to watch is not what the president tweets. It is whether Republican senators from export-dependent states decide that the political cost of continued deference to this trade agenda has finally exceeded the cost of pushing back. That is the pressure point. That is where the story goes next. Subscribe, drop your thoughts in the comments, particularly if you think the congressional path is more or less likely than I do, and share this with anyone trying to make sense of what just happened. We will be watching every development closely.